Welcome to video number 6, Basic Speed Law Defenses. In the last video, we reviewed the different defenses available to absolute speed law cases where the maximum speed limit is set by statute. In this video, I'll teach you about even more defenses that are available when you are charged with a violation of the basic speed law under Vehicle Code Section 22350. Section 22350 requires that the prosecution do more than prove that you exceeded the posted speed limit. To prove your guilt beyond a reasonable doubt, the prosecution must prove that you drove at a speed that was unsafe for conditions so that you pose a danger to other persons or property. Generally speaking, in California, if the posted speed limit is under 55 miles per hour, then you may drive at any speed, even faster than the posted speed limit, as long as your speed is safe and reasonable for the conditions. However, in addition to the officer's testimony, traffic engineering and speed surveys can be used as evidence by the prosecution to establish what speed is considered safe. In fact, if traffic or weather conditions or visibility is bad, then you could be found guilty for driving at an unsafe speed, even if you were driving slower than the posted speed limit. However, in California, a speed trap is a legal term of art, meaning that certain requirements must be met in order for a speed trap to exist. If a speed trap does exist, then it is considered illegal by the Vehicle Code, and if the police use a speed trap in your case, then the law requires that your case be dismissed. The California legislature drafted the speed trap laws to encourage the policy of police officers operating in plain sight, with the reasoning that visible police officers will have a greater deterrence to speeding and otherwise breaking laws. The legislature also wanted to discourage authorities from issuing tickets with high fines for the purpose of generating local revenue. Because of the speed trap laws, merely showing that you exceeded the posted speed limit will not be enough to convict you. In addition to the elements that we discussed in video number 5, the officer will also have to prove that the speed limit was justified with a valid traffic and engineering survey, unless an exception applies, that any radar or laser device used was properly calibrated, and that your speed was unsafe for the conditions at the time. He or she must also lay a proper evidentiary foundation by proving that he or she was properly trained to use the radar or laser device, and that the device was capable of producing accurate results in your case, in order for that speed evidence to be admissible against you. Speed limits on city streets should not be determined arbitrarily. The speed limit should be determined after transportation engineers compile a traffic and engineering survey. They will assemble a report of their observations and data to justify the posted speed limit. The DMV requires that the engineers comply with particular conditions. They must comply with methods determined by the Department of Transportation. They must consider prevailing speeds of vehicles traveling along the stretch of road, along with accident records and conditions that may not be readily apparent to drivers. Residential density and safety of pedestrians may also be considered in the survey. The speed limit should be set at the nearest 5-mile-per-hour increment to the 85th percentile critical speed. This is the speed at or below which 85% of the traffic is moving. If the speed limit is lower than this, then the report must explain the factors to justify the reduction. If the officer does not produce a valid traffic and engineering survey, then your case may be dismissed as an illegal speed trap, but there are some exceptions to this rule. The speed trap law does not apply to local streets, senior citizen zones, or school zones when children are present, and it almost never applies unless radar or laser was used to determine your speed. How do you know if you are on a local street? Generally, these are very small residential streets, but technically, a local street is one that is no more than 40 feet wide and a half-mile long, and it may only have one lane in each direction. So when officers enforce the posted speed limit on a local street, a school zone with children present, or in a senior citizen zone, then the speed trap law is not applicable. Even if radar or laser is used to obtain your speed, visual estimations of your speed by the officer are not enough for them to escape the speed trap law. If they use radar or laser and the local street and school zone exceptions do not apply, then the speed trap law applies unless they also use their speedometer to pace you. To be clear, even if they did use radar or laser, the speed trap law will not apply if they claim to have also paced you using their speedometer. But even if the speed trap law does not apply, in order to find you guilty under the basic speed law, the prosecution must still prove that you drove at an unsafe speed for conditions beyond a reasonable doubt. The prosecution must also prove that any radar or laser or speedometer used was working properly, that the officer was properly trained to use the equipment, and that the equipment was working well and capable of producing accurate results. So how do you know whether the speed trap law applies in your case? First, you must be charged with a basic speed law violation. Second, the citing officer must have used either radar or laser to obtain your speed. If so, and you are not cited in a street that is exempt, then the speed trap law applies in your case and you may have a speed trap defense. The traffic engineering and speed survey must have been conducted within the last 5 years, and it must be a complete survey that justifies the posted speed limit. If the prosecution fails to present a valid speed survey, then all of their evidence must be excluded and your case dismissed. Without a valid survey, the officer may not even testify against you. However, there are 2 exceptions to the 5-year rule. First, the traffic engineering and speed survey may be between 5 and 7 years old if the prosecution proves that the citing officer received at least 24 hours of certified radar training and an additional 2 hours if laser was used. Second, the speed survey may be between 7 and 10 years old, but no more than 10 years if the prosecution also proves that the radar or laser device was also calibrated within the last 3 years by an independent, certified calibration facility. Thus, the traffic engineering and speed survey is probably the most important component to the speed trap law in a basic speed law prosecution. So how do you know if the survey is sufficient and valid? First, it must comply with the methods determined by the California Department of Transportation as published in the latest edition of the California MUTCD. Second, it must have considered prevailing speeds, accident records, and conditions that aren't obvious to drivers, including residential density and the safety of pedestrians and bicyclists. Third, it may not be a mere summary, but should be the entire report, and it should be properly authenticated by the custodian of records. These requirements prevent the city from posting speed limits lower than most people tend to drive on any given street unless they have a good reason for doing so. The posted speed limit must be within 5 miles per hour of the 85th percentile speed unless they list legitimate reasons on the survey to justify a lower speed. This important protection helps to ensure that cities are not unreasonably lowering speeds in order to generate speeding ticket revenue. The need to make money from speeders is not a good enough reason to lower a speed limit from the 85th percentile speed. You can attack the speed survey in court by objecting to the lack of foundation, cross-examining the officer about his or her observations, and even putting on your own expert witness to explain to the court why the survey does not comply with the California MUTCD and why it should be excluded from evidence. Practically speaking, it can be difficult to analyze a traffic engineering and speed survey for the first time in court during the pressure of a trial. So you could obtain an advance copy by making a discovery request, but that could actually cause the prosecution to bring the survey to court when in reality you are hoping that they fail to bring it if it is required. Issuing a subpoena to the traffic engineering department for the document poses the same problem, in that you may be helping the prosecution build its own case against you by forcing the document into court to be used against you. Instead, it is better if you make an informal visit to the traffic engineering office before trial so that you can analyze any survey for your specific street without also causing the document to appear in court during your trial. Then, if the prosecution produces the document against you during trial, you'll be ready because you have already had a chance to analyze it. And if they do not produce it, or if they try to introduce a mere summary, then you are not obligated to confess to the existence of the complete document that you reviewed outside of court. Instead, you can make use of their failure to produce it against you to your advantage and ask that your case be dismissed. Now, even if the speed trap law does not apply in your case, or if it applies but the defense is not available for any reason, then don't forget you can still defend yourself against a basic speed law case by establishing that although you may have been driving faster than the posted speed limit, you were still driving at a safe and reasonable speed that was not a danger to anyone. This is a factual defense, so it can help you if you establish that you are not endangering any person or property by cross-examining the officer using the sample questions provided in the PDF for this video. And remember, when cross-examining the officer, be sure to try to ask yes or no questions so that you are really the one testifying and they are simply agreeing with your version of the events. You can also attack the officer's speed allegation using the techniques described in the previous video for attacking radar, LiDAR, speedometer, and visual speed estimations. If you can persuade the court that you may have been driving at a lower speed than the officer alleges, that can go a long way toward creating reasonable doubt about how safe your driving really was at the time of the incident. Then you can use your own testimony to bolster your defense, and even use an expert witness in traffic engineering to help you. Experts can be expensive to hire, and good ones can be hard to find. So another approach to getting expert testimony could be to subpoena a friendly traffic engineer from the traffic engineering department to testify as an expert on your behalf. Just be sure you talk to them in advance to be sure their testimony will be helpful, or they could end up helping the prosecution make their case. Remember, they work for the city and may not always have your best interests at heart. If you don't think they'll be helpful, then it is better just to rely on your own cross-examination and testimony to establish that you were driving safe because of things like light traffic, dry weather, good visibility, and good road conditions. By doing all these things, you will have given yourself the best chance of success, and even if the court finds you guilty of driving at an unsafe speed, you will have laid the groundwork to win an appeal, especially if the court allowed any evidence against you that was derived from an illegal speed trap. This concludes video number 6 on basic speed law offenses. Our next video will explain how to increase your chances of winning through pretrial investigation and discovery.